This is Charles speaking. Good evening and welcome to the Michigan Department of Civil Rights virtual fair housing session on rental transactions. Today's session is entitled Fair Housing Law Protects Renters Too. This session will be recorded and we will also provide copies of all materials used today after the session. As you know, from November 2023 through April 2024, MDCR held a series of fair housing hearings around the state. Through these hearings, we received well more than 8 hours of testimony from experts, service providers, and people with lived experience regarding barriers to fair housing. In June 2024, MDCR hosted a statewide summit on fair housing. During that conference, we hosted discussions regarding that testimony, as well as other sources of expertise and experience. We closed the summit with a series of recommendations for promoting fair housing in Michigan. The summit summary, including the recommendations, is available on our website at michigan.gov/MDCR. Just look for the Fair Housing Initiative link in the Issues section. Several of the recommendations requested more training and outreach regarding fair housing laws. This session today, as well as the session that was done in March, are the result of those recommendations. Both virtual events will be recorded and uploaded to our YouTube channel at MI Civil Rights. My name is Charles Schroeder, and I'm the Director of Community Engagement for MDCR. I will be your moderator this evening. Please take a moment to confirm you have the most recent Zoom updates and are in gallery view during the session, as we will be screen sharing. We will be using the Hide Non-Video Participants function to allow better focus on presenters. Presenters and ASL interpreters will be spotlit by the host. Remain on mute to avoid background noise. We will be using the Q&A function for our questions today, and you may submit your questions in this area at any time throughout the presentation. Let us know if you need any technical assistance or contact Zoom directly via the Zoom Help Center. We have a dynamic panel of presenters who will discuss the critical importance of understanding and complying with fair housing laws, as well as recognizing and addressing bias in rental transactions. This session will provide information pertaining to your rights and responsibilities when renting a home. Without further ado, we're going to jump right into today's topic. Our first presenter comes to us from MDCR's Office of Legal Affairs. Alana M. Buford-Kamerman is the Acting Director for the Office of Legal Affairs. She obtained her bachelor's degree with honors in anthropology and political science from Bard College at Simon's Rock in 2012. She graduated magna cum laude from Michigan State University College of Law and passed the bar in 2016. Before becoming a civil servant, Alana was a distinguished civil litigator in both state and federal courts. She joined the state of Michigan in April 2021 as a staff attorney at MDCR, where she advised enforcement teams on cases as they progressed through investigation, conciliated resolution between parties, and prosecuted cases in the administrative process on behalf of the department. Please welcome Alana as she shares information on fair housing laws. Alana, you now have the platform.
This is Alana speaking. Thank you for that introduction, Charles, and thank you everybody for attending today's virtual session. We are extremely excited and happy that you're here with us this evening. First, want to introduce you all to Civil Rights, MDCR, the Michigan Department of Civil Rights, what we do in terms of enforcement and how that process works. So if we could please move to the next slide. Now, it wouldn't be a presentation from an attorney if, of course, there wasn't a legal disclaimer in advance as the first slide. So please do note that the information contained and provided in this presentation does not and is not intended to constitute any type of legal advice. All of the information, content, and materials used in this presentation are for general information, educational purposes only. and are not a determination of any one individual's particular legal rights. So with that out of the way, let's talk a little bit more about MDCR. Next slide, please. So in order This is Alana speaking. I think we experienced a moment of technical difficulties. So I want to ensure that everybody can see the presentation. If not, though, I know this material. Yay, here we go. Okay. Y'all, we say here at the department, we don't panic, we pivot. So moving right along, let's introduce you first to MDCR itself. Next slide, please. So, there we go. So the department itself is actually an extension of something else, specifically the Michigan Civil Rights Commission, which is an 8-member commission that was established by Michigan's Constitution in 1963. In accordance with the Constitution, the commission is required to secure the equal protections of civil rights for all individuals within the state of Michigan. The members of the Civil Rights Commission are appointed by the governor and then confirmed by the state Senate. So, with the establishment of the commission, MDCR, the Department of Civil Rights, was created to oversee the day-to-day operations of securing those equal protections of civil rights. So this means your enforcement, education, as well as community engagement. Next slide, please. So in accordance with this directive, MDCR sees itself as the operational arm of the Michigan Civil Rights Commission and is a state law enforcement agency. Right, I want to be very firm and clear on that, right? MDCR is a law enforcement agency. It does not advocate for any one individual's rights or defend any entity's rights either. MDCR is an objective, neutral fact finder that works to, one, secure the equal protection of civil rights for all, right, in the interest of the public. 2, to investigate allegations of unlawful discrimination within the state of Michigan. Resolve complaints of unlawful discrimination. Promote voluntary compliance with civil rights laws, as well as in a form of proactive enforcement, right? Preventative enforcement, do outreach and education, such as tonight, in order to help ensure compliance with civil rights laws before violations occur. So next slide, please. So let's now dive into what does enforcement look like and what are some of those civil rights laws themselves that are being enforced by the department. Next slide, please. So within MDCR's enforcement division, the department handles the processing of intakes, right? So when individuals bring their allegations to the department, processing those, writing the certified complaints based on those allegations, the investigation of those allegations. So that's where you're exchanging documents or interviewing witnesses. Additionally, the department facilitates resolution, so essentially mediating between the parties to reach a settlement agreement. But if no resolution is reached and the investigation shows a violation occurred, then the department would work to prosecute the unlawful civil rights violations. And so, again, I'm going to reinforce and state, right, MDCR is a law enforcement agency and not advocating or defending any individual party. The department seeks to promote the public interest, to protect the public interest in civil rights violations. So when it comes to housing, next slide, please. In particular, housing discrimination for the department's purposes is defined as housing discrimination based on any of the protected categories prohibited by law. And that specifically applies to either buying, financing, or renting a place to live or do business, as well as any of those property owners' advertisement of those places to buy, finance, rent, or do business as well. So you'll see, next slide, please. You'll see this manifest on issues of certified complaints in the form of eviction or refusal to rent, failure to accommodate disability, advertising, sexual and other discriminatory harassment, other terms and conditions, refusal to sell, redlining or steering. So this is, that's defined as essentially trying to push or segregate an individual based on their protected class status out of a specific neighborhood or out of a specific dwelling due to their protected class status. And then finally, potentially failure to loan. So those are the types of issues, but under what laws does the department have the authority to do such investigations? So there are actually two laws, and yep, they're both up here. So the first is the Elliott-Larsen Civil Rights Act, and that allows protections on the basis of race, color, religion, national origin. Later tonight. This is Alana speaking. Apologies for that interruption. I will wait to continue until the slide is up. Thank you. All right. And as I was saying before, as of about 3 weeks ago, source of income, that's our newest protected class status. And you will hear more about that here in just a few minutes from one of the department's staff attorneys. Additionally, the department also has authority to investigate under the Persons with Disabilities Civil Rights Act. And that protects individuals specifically on the basis of disability. For either of these statutes, if a person experiences a form of an adverse action, right, an event that negatively impacts their rights in regards to housing, an individual would have 180 days from the date of experiencing that harm to bring those allegations to the department for them to be considered timely. And that's that statute of limitations. Roughly 180 days translates to about 6 months. Next slide, please. Additionally, the department also has a partnership with HUD, the Housing Urban Development. And through its partnership with HUD, the department's authorized to investigate and prosecute violations of the federal civil rights laws in the area of housing. And Title 8, or also known as the U.S. Fair Housing Act, so sometimes known as the FHA, protects individuals on the basis of race, color, religion, national origin, sex, gender identity, familial status, as well as disability. And under this federal law, the statute of limitations is a bit longer, as an individual is provided 365 days. So that full 1 year from experiencing that date of harm. So next slide, please. So that's the general brief overview of the types of issues that the department investigates, as well as what protected class status is. But let's talk a little bit about then, what does this look like during, and what does an actual investigation look like for purposes of the department? So, next slide, please. So during the investigation, MDCR will determine whether or not a violation of a civil rights law occurred. In doing so, the department is impartial. It doesn't take any party, one party side. The accuser, i.e. the claimant, the person who alleges that their civil rights have been violated, or the alleged violator, the respondent, and doesn't take a side. The department works to be an objective, neutral fact finder. Find the facts and report on the facts to determine, did a violation occur of the law? Now note, just because an individual files with the department does not mean that the individual is precluded from taking their claims to a court, right? The MDCR works to process violations administratively, and individuals are allowed to still seek private counsel and file in court should they wish to do so. Next slide, please. So the actual investigation process allows first the claimant to file their certified complaint. That's where the claimant brings their allegations. And once that has been filed, the respondent will have an opportunity to present their side of the story and present any evidence in support of their defenses. Additionally, during the course of the investigation, especially in the area of housing, an investigator may go to a site, right, an actual dwelling or rental unit, conduct interviews of witnesses, the alleged rental property owners, claimant, any witnesses claimant identifies, as well as review of documents, especially in the area of housing. We see things such as, text messages exchanged between a tenant and a landlord, or emails, or the actual lease agreements themselves. All of that's gathered by the department during the course of the investigation and reviewed by the investigator. Additionally, as mentioned before, right, the department does work to promote resolutions between parties. And during that time, both parties can provide different things that might help make them whole, maybe trainings for a landlord, or maybe back pay of rent for a certain period of time when things, when accommodations may not have been provided, for example. Now, resolution discussions occur as early as that intake process. So the moment an individual comes to the department with their allegations of having experienced discrimination. If both parties agree to a settlement agreement, that will close the investigation. But if no settlement is reached, then the department will write out all of its findings in what's called an investigation report. And at that point, determine, is there sufficient evidence for a case to be prosecuted, or does the case need to be closed due to a lack of evidence? Next slide, please. So, like I said, possible investigation outcomes. First, if there's a lack of evidence, that's going to result in a dismissal, where there's insufficient evidence to support a charge of discrimination. At that point, the department's investigator will complete an exit interview with the claimant, explaining what's lacking in the investigation. At that point, the claimant can ask for reconsideration, i.e. an appeal of that decision. Alternatively, though, if the case does have enough evidence to support a charge or show that a violation occurred, the case will move to conciliation. So this will be when there's a conference between a staff attorney and respondent, and the staff attorney is going to encourage the respondent to address the discrimination and to prevent it from happening again. But sometimes conciliation itself, or at least that's the next process stage, conciliation itself can have its own outcomes. So, next slide, please. Ideally, right, we love to see resolution. As stated before, we start that process as early as intake. And conciliation is really like that last chance opportunity before a charge is filed, before the prosecuting of the case occurs and we're at a hearing. Now, do note, right, as a prosecuting agency, as a law enforcement agency, the department does have the authority and ability to enter into what's called a consent agreement with respondents, which is akin to a plea agreement with respondents to address the public interest concerns raised in the certified complaint. Individual claimants themselves are not parties to those consent agreements. And if they wish to appeal those, they can through an appeals process provided by the commission. Alternatively, though, if the parties don't settle, the respondents continues to be non-compliant and doesn't want to address the public interest concerns, then a charge would be filed. And so in that instance, the department will file essentially what looks like a complaint filed in court, alleging the violations that were found during the course of the investigation, and request that an administrative law judge issue a recommendation finding to the Civil Rights Commission to hold that respondent accountable for its violations. So let's talk a little bit about what a hearing would look like. Next slide, please. So a hearing itself is what people kind of think of like a trial. There's what's called an administrative law judge present, and that administrative law judge will preside over a hearing. And the hearing will be where witnesses testify under oath, the rules of evidence apply when documents are being submitted, and each party has the right to cross-examine all of the witnesses that are called. After that hearing takes place, the hearing officer, like I said, who's the administrative law judge, will issue a proposed decision, concluding whether discrimination took place, and if so, what's the appropriate remedy. And this is Alana speaking. I'm going to wait for the interpreter.
I'm here.
Oh, thank you. I just didn't see a spotlighted on my screen. Apologies. Alana speaking again. So the Civil Rights Commission is the final decision maker in any civil rights investigation. So after a hearing, the ALJ, the administrative law judge, will issue its decision or proposed decision, and the commission will say yay or nay. Does it accept the proposed decision? Does it want to include additional penalties or remedies? Or maybe sometimes even hold a whole new hearing itself. Now, if a claimant or a respondent disagrees with the commission's final order, they do have a right to appeal that decision to a circuit court to review the case. Now, again, just another note, just a reminder, note that filing a certified complaint with the Department of Civil Rights doesn't prevent the claimant at any time filing a case in civil court on their own with private counsel. So with that, I appreciate all of your grace during the technical difficulties. Thank you for your time, and I will now return it back to Charles.
This is Charles speaking. Thank you, Alana, for that informative and educational presentation. It's crucial to be aware that of the laws that protect against discrimination and to ensure that everyone has a fair some technical difficulties. It's crucial to be aware of the laws that protect against discrimination and to ensure that everyone has a fair chance in important aspects of life, like renting a home. I would like to remind our viewing audience that all questions will be read at the end of the program, and I'd like to thank the viewing audience for sticking with us as we experience occasional Zoom issues. As we continue our focus on fair housing protections, we are going to move to a new area of protection under Michigan law, source of income. MDCR staff attorney Catherine Cooper will share her insight on this topic. Staff attorney Cooper works for the Michigan Department of Civil Rights, or MDCR, as an administrative law specialist, where she has been contributing her expertise for just over a year. Catherine graduated from Thomas M. Cooley Law School with a Juris Doctor degree and successfully passed the bar exam in February of 2021. Staff attorney Cooper began practicing law in May of 2021 and has since gained valuable experience in the fields of landlord-tenant law, real property law, and fair housing laws. Throughout her career, Catherine has demonstrated a strong commitment to the legal profession and a dedication to serving her community. Catherine, we're so glad to have you with us today and eager to learn more about your presentation.
This is Catherine speaking. Hello and good evening. My name is Catherine Cooper, and I'm a staff attorney with the Michigan Department of Civil Rights. I work primarily with the housing teams in the enforcement division, and I've been tasked with explaining the source of income protections recently added to the Elliott Larson Civil Rights Act, which I will be abbreviating for the remainder of this presentation as the ELCRA. Next slide, please. As I'm sure many are aware, the Elliott Larson Civil Rights Act, or the ELCRA, was amended on April 2nd, 2025 to cover source of income discrimination under Article 5, which governs the area of housing. Today, we will discuss how the amendments define source of income discrimination, what entities are covered, and what parties are protected by the source of income amendments. Next slide, please. The ELCRA source of income definition can be found in MCL 554.601, Section 1. This area of law governs the landlord-tenant relationships. It makes sense that this definition can be found there. And it reads that source of income includes benefits or subsidy programs, including housing assistance, housing choice vouchers under 42 USC 1437F, public assistance, veterans benefits, Social Security, supplemental security income, or other retirement programs, and other programs administered by any federal, state, local, or nonprofit entity. In short, the income protected by ELCRA must be a benefit or a subsidy administered by a federal, state, local, or nonprofit entity. The definition just includes some examples of these protected benefits and subsidies, but it's not limited to those. It can also be just any benefit or subsidy administered, once again, by the government or a nonprofit. Next slide, please. The source of income definition provided in MCL 554.601, Section 1 excludes any income a prospective tenant can't prove is legal and ongoing. So a potential tenant can be required to provide that the benefit or subsidy they are attempting to use as protected income under the ELCRA is from a legal source and that it is ongoing. It won't be a violation if a landlord requires that a potential tenant or a tenant provide that information. Next slide, please. This definition also excludes any housing assistance that is not approved by the appropriate agency within 30 days after the landlord provides all information required as a condition of the agency's approval, including evidence that all repairs required before occupancy have been completed. Basically, the benefit or subsidy that is protected income under the ELCRA likely requires recertification if there are changes to a tenant's income, job status, familial status, or is just a yearly requirement of the federal, state, local, or nonprofit program. In these cases, if the benefit or subsidy program is not approved within 30 days of the landlord and the tenant submitting their required documentation, then that benefit or subsidy will not be protected by the ELCRA. Next slide, please. The Housing Choice Voucher Program, or HCV, is one of the largest federal subsidy programs in the state and allows covered tenants to seek housing in the private sector. Tenants with HCVs receive a federal subsidy administered by the Michigan State Housing Development Agency, commonly known as MSHDA, to cover a portion or 100% of their rent. So it could be very small, like 5 or 10%, and it can go all the way up to 100% of their rent. That subsidy can. Public retirement benefits include pension, 401k, investment retirement accounts, or IRAs. Well, they're commonly known as IRAs. These distributions that are provided upon retirement, those benefits are going to be protected under source of income. Veterans benefits are protected as well. That includes VASH vouchers. VASH vouchers are a mixture of the HCV program that I stated earlier, in addition to some other veteran benefits. Those protect the source of income protections will cover those benefits and subsidy programs as well. Next slide, please. Social Security and supplemental security benefits, commonly known as SSI and SSDI. That's also going to be protected income under the ELCRA. Once again, any benefit or subsidy administered by any federal, state, local, or nonprofit entity will be protected under the ELCRA source of income protections. So on the slide, we have nonprofit organizations, local government, state and federal government, all of those programs, if it's a subsidy or a benefit program, and it's ongoing, it's going to be covered by source of income protections. Next slide, please. The people or entities that are covered, anyone renting land, a structure, a building, or a portion of a structure or building for the residential use of a tenant will be covered by the ELCRA source of income protections. Some examples include apartment buildings, boarding houses, rooming houses, mobile home spaces, and single and two-family dwelling units. That doesn't mean that these are the only dwellings or rental units that apply to source of income protections, but just some examples for you there. Low income housing tax credit properties are properties that receive government subsidies directly on their tenants' behalf. And they're typically site-based as opposed to moving about to different areas like a housing choice voucher. A housing choice voucher is mobile. Low-income housing tax credit properties are stationary. It's typically an apartment building or uh-oh. This is Catherine speaking, waiting on the interpreter. Okay, looks like we're back on. Thank you for being patient with us during our technical difficulties. The types of housing that is going to be covered by source of income protections under the ELCRA include any land, structure, or building or portion of a structure or building that is being used for residential purposes for a tenant are going to be covered. Some examples include apartment units, boarding houses, rooming houses, mobile home spaces, and single and two-family dwelling units. Those are just some examples. Once again, it's not limited to just those examples. Low-income housing tax credits are properties that receive government subsidies directly on behalf of their tenants. They are also going to be covered by source of income protections. Once again, low-income housing tax credit properties are stationary and similar to a housing choice voucher, but the difference is that the housing choice voucher is mobile, where you can move between low-income housing tax credit properties and also private rental units with the consent of your landlord. You can use your HCV voucher to rent out private housing or a condominium, that kind of thing. Next slide, please. So who are the covered parties? Anyone who could be a potential tenant or is a current tenant are going to be protected by source of income amendments to the ELCRA. All persons engaged in rental transactions are covered by the source of income amendments to the ELCRA. Some examples include property managers, rental agents, real estate agents, and or brokers. Next slide, please. All landlords are covered by the ELCRA source of income amendments. Once again, MCL 554-601 Section 1 defines a landlord as any individual, owner, lessor, sublessor, partnership, corporation, association, limited liability company, or any other legal entity that offers residential rental units for rent. In short, anyone engaged in rental transactions are covered by the ELCRA source of income amendments. And just a side note, low-income housing tax credit properties are actually prohibited under their federal subsidy from discriminating against voucher holders and are also going to be covered under the state law under the source of income amendments under ELCRA. Next slide, please. MCL 37.25024 defines what kinds of landlords are exempt from the ELCRA source of income amendments. So here we go. Any landlord with less than 5 rental properties or units will be exempt from the source of income amendments to the ELCRA. Next slide, please. Any person living in a rental unit or property without the consent of the landlord and without paying consideration will not be covered under the ELCRA source of income amendments. So these individuals are commonly called squatters, but these are just people who maybe they're a holdover tenant, which means that they did not renew their lease and the landlord doesn't want to proceed with a landlord-tenant relationship and they're not paying any consideration or rent to the landowner or the landlord. They won't be able to use the source of income amendments in ELCRA as a defense. And also, this also applies to emergency rental assistance. If a landlord requires an income threshold. So typically landlords require, that you have to make a certain amount of money in order to rent from them. And tenants or prospective tenants, current tenants or prospective tenants cannot use emergency rental assistance in that determination for their income. So that is another exception to the source of income amendment protections under the ELCRA. Next slide, please. So what you can look for when you perceive that you may be being discriminated against based on the new source of income amendments under the ELCRA, requiring additional references when other tenants who use W-2 income or work income are not being required to provide additional references, imposing additional or unreasonable screening criteria on those who receive subsidies and benefits from the government versus those who are paying out of pocket exclusively from earned income. They're not being given additional or unreasonable screening criteria. An example of unreasonable screening criteria could be requiring like a cosigner when you don't require that from someone who has like earned income as their income for the determination. Requiring a larger security deposit for those who receive subsidies or benefits when those larger security deposits are not required for people who use earned income on their rental application or to renew their lease. Imposing other additional fees or penalties. For example, if you use subsidies, federal subsidies, state subsidies, local subsidies, or benefits on your rental application or to renew your lease, landlords should not be charging you extra fees or penalties for them having to look into that or research that or double check that. That should not be done because when people with earned income provide their earned income information, it's not typically done for them. So we just want to keep a even playing field here. So those are some things that you can look for. The biggest one is going to be ignoring voucher payments when determining if an applicant meets the income requirements to afford a unit. And this is going to be for rental applications and for current tenants. Things change while you are a tenant. And so sometimes you have earned income that meets the income requirements, and then sometimes you don't, and you might be relying on a government subsidy or benefit to meet those income limitations imposed by the landlord. The landlord cannot ignore those subsidies or benefits when making the income determination. So you can definitely look for all of these things, but that's going to be a big one. Next slide, please. This is the contact information for the incomparable Director of Legal Affairs, Alana M. Buford Cameraman, and for myself, if you would like to contact us. But all questions, I believe, are being reserved until the end. And we are back in your hands, Charles.
Thank you, Catherine, for sharing your knowledge about this new area of protection in Michigan. I'm sure our viewers will have some follow-up questions on this topic. Next, we are going to share some examples of fair housing cases that MDCR has investigated. We are fortunate to have Lashia Sharp, who is a civil rights manager within MDCR's housing unit. Lashia was born and raised in Detroit, Michigan. She's a graduate of Wayne State University and holds a bachelor's degree in political science with a minor in communications. She is also a graduate of the Academy of Court Reporting with a post-bachelorette certification as a paralegal. Currently, she's a graduate student at the University of Miami. Lashia has worked in state government for 19 years and diligently serves the public in all facets of her life. Lashia, thank you for being with us today. You have the platform.
Thank you, Charles. This is Lashia speaking. Examples of housing cases we see related to rentals would include cases where rental properties have a no pet policy and an applicant or a resident is now requesting an accommodation because they now need a assistance animal or an emotional support animal. We've seen cases where the respondent or the housing provider has required specific forms to be completed that they house, and that if those forms are not completed, then they don't deem a request has been made. That would be inappropriate. And so we see cases like that where they are requiring specific forms and they should not be doing that. So we've seen cases like that. We've also seen recent cases where a housing provider has decided, because the request has been made and the documentation, the supporting documentation, the medical documentation to support the need for the assistance animal or the emotional support animal is from a doctor that's out of state, that it can't be valid. That's a recent case, and this person had just recently moved from another state. So all of her medical information was not in Michigan. Her doctors were not in Michigan. And the housing provider just determined that because, it's not a Michigan doctor, that this information cannot be valid. We see cases like that. We also see cases where claimants have had a positive experience technically and verbally over the phone. They've been given all the terms, they've been approved for the lease. And then when they show up in person, they feel something different and they also experience something different. Claimants allege that once their race was visible and it was clear that the circumstances, the requirements, the deposits, things like that changed once their race was clear, once they were in person. So we've seen cases like that. We've also seen cases based on sex where the housing provider has made what they call fun statements or lighthearted statements about potentially spanking the claimant and offered alternative ways of paying their rent. And also the same housing provider required additional funds when they saw a male visitor at the home. That's a current case that is going all the way to conciliation at this time. So we see all different types of cases. We also see cases where retaliation has been alleged. The claimant or the resident may have made a recent complaint to another entity at the property regarding racial discrimination, or they may have requested an accommodation recently, and then all of a sudden they start receiving an eviction notice, or they start receiving fines or violations for things that in their mind haven't even occurred or may have occurred but never were an issue before. And so we've seen retaliation complaints based on things like that. We've also seen testing cases where potentially a difference in outcomes have occurred for comparable applicants. So the Caucasian applicant and the African American applicant may have gone in on the same day, talked to the same person, and had totally different outcomes. One may have been told that there was nothing available, and one might have been showed the vacant property that same day. So we've seen all different types of cases, and it's important to know that everything is an allegation until it's substantiated through the investigation. For example, we've seen a recent case where the claimant filed a complaint regarding an alleged discriminatory eviction based on race. However, there was clear documentation of a destruction of property situation that had gone on for years. That was in the courts that they had been trying to evict the claimant for a very long time. So much so the property, it was such a bad situation that 5 months after the investigation was done, the property is still inhabitable. So we get all types of allegations and we see all different types of cases, and it's never a dull moment. So we see all different types of cases and we investigate them all individually, and we hope that the training will assist in housing providers and the public just knowing their rights and what is appropriate and what is not appropriate. Charles?
Thank you, Lucia, for enlightening us about the type of fair housing cases that are filed with MDCR. Please submit any questions about this topic in the Q&A box, and we will answer as many as possible at the end of the presentation. Our next presenter will address implicit bias in the decision-making process and how awareness of unconscious preferences can help prevent unintended discriminatory practices and outcomes in rental transactions. We are joined by Alfredo Hernandez Corson, Director of MDCR's Development, Innovation, and Access Division. Alfredo was born and raised in Panama. He moved to the United States in 1990 and joined the U.S. Army at the age of 20. He spent 5 years stationed in Honolulu, Hawaii, before moving to Illinois in 1997 and Michigan in 1998. Alfredo obtained a bachelor's degree in liberal studies with a philosophy minor at Grand Valley State University, where his work, Language, Culture, Perception, and Knowledge, was published in the McNair Scholar Journal. He pursued his graduate studies at Western Michigan University, where he earned a master's degree in comparative religion. Alfredo was a McNair Scholar and Thurgood Marshall Fellowship recipient. Alfredo has worked for numerous years developing innovative and inclusive strategies for organizational change. He has taught college courses in philosophy and cultural anthropology, and he currently serves as the Equity and Inclusion Officer in addition to his role with MDCR. Alfredo, we are delighted to have you today and look forward to hearing your presentation. The platform is yours.
Good afternoon, Charles. Thank you very much for that kind introduction. And good afternoon, everyone. And thank you for inviting me to be a part of the discussion this afternoon. Today, as it was mentioned previously, I will talk a little bit about implicit bias and its impact in the decision-making process. It is always useful to gain a deeper understanding in terms of how implicit bias can generate discriminatory practices and outcomes. It is also important to think about how equal access is impacted by biases and how they impact client relationships and renting decisions. I will also touch base briefly on best practices to mitigate personal and interpersonal biases and assist in the prevention of unintended discriminatory practices. We know that implicit bias can influence how renters advertise their properties, potentially excluding certain groups from the market. Research has shown that implicit bias can have severe consequences, leading to disparities in housing and perpetuating social and economic inequality. As we begin to explore the topic of implicit bias, I believe that it is important to provide a foundational definition. For the purposes of this presentation, we will define implicit bias as the attitudes or stereotypes that affect our understanding, actions, and decisions in an unconscious manner. When we explore the root causes of implicit bias, we recognize the role that culture and societal messages play at shaping how we experience our experiences. It is of vital importance to understand how implicit bias impacts us, the work we do, and the people we serve. Most people will admit to have biases, yet not everyone who acknowledges their own biases does the work to mitigate them. Acknowledgement is an important part of the process. The next and very important step is to engage in the work of mitigating biases. This means that we begin to identify what these biases are in effort to effectively mitigate them. In efforts to effectively mitigate them. As we explore the impact of implicit bias in deeper ways, let us remember that as a society, we consciously embrace principles of justice and fairness. Yet at times, especially when we're tired, stressed, busy, or distracted, we may experience a disconnect between our conscious values and our unconscious biases. For that reason, it is important that we work to understand the difference between our conscious values and unconscious biases. Part of the work of understanding the practice of discrimination today is that as a society, we do not tolerate explicit racism, sexism, and other discriminatory practices. That is not to say that explicit discrimination does not exist, but simply that as a society, it is against the law to discriminate based on certain protected classifications. Yet, discrimination on this basis does exist, and it is not only in the space of explicit discrimination. Research on implicit bias reminds us that discrimination today often takes place at an unconscious level. We understand there are three root causes that shape implicit bias. For the sake of time, we'll briefly go through them. The first one is that as human beings, we are inevitably we gravitate towards forming in and out groups. This is a human predisposition based on a survival instinct, where we gravitate towards the familiar, towards what is known to us, towards what we see as safe. We also know that we're impacted by polarized messages, and those messages also lead us to form in and out groups. And we also follow, our brain follows cognitive scripts, and those cognitive scripts sometimes place us in autopilot, and generally also generate unintended outcomes. So when we think about barriers to equal access shaped by biases that we have sort of talked about a little bit, we know that they can impact client relationships and housing decisions and real estate, renting. We understand that there's ample data that points to the problems. For instance, a 2023 Fair Housing Trends report from the National Fair Housing Alliance recorded 33,000 plus complaints of housing discrimination in 2022, more than in any other of the previous 25 years since the organization began tracking these incidents. More than 53% of the complaints were discrimination based on disability, 17% were race-related, and 7.5% were gender-based. We recognize a lot of discrimination can be very subtle and many times undetectable. A lot of consumers often may not even know when they have been treated differently. Discrimination can be hard to identify. At times, the service provider will work with the consumer in some sort of superficial fashion, which do not lead to positive outcomes. Unfortunately, discriminatory practices may not always be obvious, making it essential to know the subtle indicators of bias. Some common forms of housing discrimination may include the refusal to rent or sell based on protected characteristics, refusal to show a unit, denying an application without reason, or telling someone a unit has been rented when it hasn't, are all examples of discriminatory practices. For instance, if a landlord repeatedly tells applicants of a particular ethnicity that no units are available, but then rents to others, this could be discriminatory. Different rental terms or conditions, applying different rental standards, such as requiring higher deposits from certain applicants, imposing stricter lease terms, or requiring certain groups to undergo additional checks is another form of discrimination. There's discrimination in advertisement, discriminatory language in rental leasing, such as specifying no children, no single mothers. This violates the Fair Housing Act. While blatantly discriminatory language is illegal, some landlords still use code language to subtly discourage certain renters. Excuse me. We also know that there's the practice of steering when landlords or agents guide people towards or away from certain neighborhoods based on their race, ethnicity, or religion. This practice is illegal and perpetuates segregation within communities. We also know there is the refusal to make reasonable accommodations. We know that under fair housing laws, landlords must make reasonable accommodations for tenants with disabilities. This could include installing ramps, allowing service animals, or providing accessible parking spaces. Denying reasonable requests based on a person's disability is discriminatory and illegal. As a consumer, you always want to educate yourself when you go out into the marketplace to engage in a commercial transaction and learn what your rights are. Housing discrimination remains a pervasive issue, but understanding your rights and the resources available can empower you to take action. By documenting incidents, reporting discrimination, and seeking legal help, you can fight back against unfair treatment, and contribute to creating a fair housing market. Standing up against discrimination not only protects your rights, but also helps to ensure that future renters and buyers have access to equal opportunities in finding a place to call home. You can, of course, reach out to your local fair housing agency. And if you believe you've been a victim of discrimination, you could also reach out to the Michigan Department of Civil Rights. I recognize that when we think about biases and disparities generated by implicit bias, that sometimes we feel a bit hopeless about the situation. The good news for service providers is that biases are malleable and can be unlearned. This work involves the construction of new mental associations, as well as the practice of breaking a habit which requires intention, attention, and time. To wrap this up, we all have a social responsibility to be a part of the solution. As a consumer, please know the resources available to you, know your rights, including your right to file a discrimination complaint if you feel you have been the victim of discrimination. As a service provider, continue to do the work to understand the laws that protect your agency, as well as the consumer, and continue to work to mitigate biases at a personal and interpersonal level. Thank you for your time.
Thank you, Alfredo. Implicit bias can profoundly impact the rental process, leading to serious and harmful consequences. Your presentation highlighted the influences these biases may have on rental transactions, and you provided valuable insights. Our upcoming presenter will discuss accommodation requests in the context of rental transactions. We are joined by Tyra Khan, who began her public service career in 2002 with MDCR and has worked in varying roles, including civil rights investigator, staff attorney, ADA compliance unit manager, and currently leads the Disability Rights and Compliance Division. She oversees the division on deaf, deafblind, and hard of hearing, FOIA, contract compliance, and ADA compliance units. Tyra is a licensed attorney with special interest in disability law, accessibility, and fair housing. She completed training courses through the National Fair Housing Training Academy in Washington, D.C. on fair housing investigations, conciliation for investigators, and litigating fair housing cases. Tyra is a certified ADA coordinator and is currently appointed as the ADA coordinator for the state of Michigan. Tyra, welcome, and the platform is yours.
This is Tyra speaking. Good evening, everyone. I'm very happy to be joining once again to talk about something very near and dear to my heart, fair housing. Alana did talk quite a bit about and gave us a really good presentation about the law, so I'm not going to go into it too much. But as Charles said, I will be talking about something that really is prominent in fair housing, reasonable modifications and accommodations. Next slide, please. I won't go into the disclaimer again. Alana already gave it to you, but just know that this does not constitute legal advice, and we're sharing this information for informational purposes only. Next slide, please. So a little bit about the law. Alana again gave us a good overview. There are a couple different laws, 3 different laws, sometimes 4 that apply when we talk about fair housing. There are 2 federal laws that primarily cover most housing that we know that folks live in. The Fair Housing Act, which we've already discussed, it prohibits discrimination by a number and a broad area of housing providers. Real estate companies, also in the lending institutions and banks, insurance companies who provide homeowners insurance, and then it also covers advertising, as Lashia had mentioned before. I'm going to talk primarily about these things when it comes to disability status, and it also protects folks with an association with a person with a disability. So you may not be the person with a disability, but someone in your home is, and so you're also protected with that relationship there. We also have another federal law called Section 504 of the Rehabilitation Act, and it prohibits, similar to the Fair Housing Act, covers the same types of protections, but it applies to housing programs that receive federal financial assistance. So if there's one federal dollar that flows through a federal a housing program, not only do they have to comply with the Fair Housing Act, but also Section 504 of the Rehabilitation Act. And I'll talk about that a little bit more later. I do want to mention that a lot of folks think that the Americans with Disabilities Act, or the ADA, applies to all housing. There is limited scope and jurisdiction for that law for when it comes to housing. It's only when the housing opportunity is provided by your state or local government. So if you're thinking about correctional institutions, housing authorities, public housing, some types of group homes and long-term shelters, generally those would be covered by the ADA. And sometimes the laws overlap in terms of those protections. I just wanted to mention that because we do usually get a question about the ADA. And then that brings us to our state law, Michigan Persons with Disabilities Civil Rights Act. It is very similar to the Fair Housing Act, and under Article 5, it specifically carves out protections for housing, and it prohibits discrimination based on disability status, again, by housing providers, real estate companies, banks, and other types of lending institutions, your insurance companies, again, and advertising. And it also provides those associational protections as well. Next slide, please. So getting right into the meat and potatoes of what is an accommodation. We hear this word a lot in fair housing. We hear modification. So I'm going to tell you the difference between the two. A reasonable modification accommodation is one area of the law. It's one potential type of prohibited discrimination, and that is the refusal to provide reasonable accommodations. The definition is any change in the rules, policies, practices, or services that are needed to provide equal opportunity for folks with individual disabilities to use and enjoy whatever the rental opportunity is, whether it's a condo, an apartment, a home that's for rent or for sale. But it also includes those common areas too. So if it's a leasing office, if there is a pool, a community pool or playground there, it applies to all of those common areas in addition to your living space. So some types of accommodations are, and this is not an exhaustive examples by any stretch, just a few to give you an idea. So sometimes people need an assigned or designated accessible parking space. So housing providers they don't have to provide parking to their tenants, but if they do, then, and if someone needs accessible parking, they have to assess whether or not that's a reasonable accommodation to do so. Another type of change would be adjusting your rent payment schedule. So if you receive disability related income, your checks on a certain day of the month, but your rental payment comes at a different time at the opposite end of that month, and you're having difficulty managing those payments, a form of an accommodation may be for your landlord or housing provider to adjust your rental payment schedule. And then another type of or example would be if you need to transfer to a vacant unit that meets your needs. If you're currently on a third floor unit and your condition has changed such that there's no elevator and you're not able to traverse up and down the stairs, and there is a vacant unit on a ground floor, they have to consider that as a change or an accommodation to you. When we're talking about accommodations, again, those are changes in the way things are normally done, policies or practices or services. The housing provider generally pays for those unless they can show that providing the specific accommodation that you ask for results in an undue financial and administrative burden. And those are kind of legal terms of art, but what it means is they're based on the totality of their resources, it would be a financial hardship for them to do it. But also the law adds an extra layer of protection, and it says not just financially do they have to show too great of a burden. They also have to show that it's an administrative burden, meaning it would be too complex for them to allow you to have that accommodation. Maybe it's a staffing issue. Maybe it's the structure of the way things are set up there. They have to be able to show those both to deny it. Next slide, please. So on the flip side of that coin are what we call reasonable modifications. And when we talked about accommodations, it was changing a rule or policy, but here we're talking about a physical change to the housing unit or a common area. So it's a structural change that enables a person with a disability to use and enjoy that space. Again, it can be to the inside of the apartment unit itself, or to those common areas like widening a door. We have that as an example, widening a doorway. Installing a ramp is a very common one that we see, or adding grab bars to a bathroom, or extra grab bars to a bathroom to allow the person with a disability to safely use their bathroom. Now, when we're talking about modifications, those are generally paid for by the tenant. The only exception to that is in what I mentioned earlier, the federal law, section 504. If that housing provider receives federal funds, then they are responsible for paying for reasonable modifications. And reasonable is not again a word that means you don't always get what you want, but you will get what you need, right? Like to quote the Rolling Stones. Um, it i- it's something that you need, but it may not be in the form that your primary consideration, but as long as it's effective and usable for you, um, it's something that the housing provider will have to provide. Next slide, please. So making a request. The law does not require that a request be made in any particular manner or at a particular time. Lashia had mentioned earlier that sometimes housing providers will say to a tenant, if you want if you want your service animal, or if you want a accessible parking space, you have to have your doctor fill out my form. Well, a lot of doctors don't do those things, and it's not the tenant should not be punished for that. So the law says that landlords have the right to reasonable documentation and assurances that allow them to know that the person is a person with a disability, but they don't have a right to know their, deep dive medical history or diagnosis. just that they meet the definition of a person with a disability under the law, and that there is a specific need for something to be changed or altered. Requests don't have to be in writing, but it's recommended to do that if possible, if you're making your request, to put it in writing, just so there's no misunderstandings there. No specific words are required either. It's just important to make clear that there's a disability related need for what you're asking for. And we just recommend that you explain the type of accommodation or modification that you need, and then the connection between the two if it's not known or apparent. And requests can come from the person with a disability, or they can be made by someone on their behalf, a family member, a friend, an advocate, an attorney. It doesn't really matter. Next slide, please. Responding to a request. So now we're going to talk about the obligations and requirements for the housing provider when they receive a request. Housing providers have to provide a timely and prompt answer. What that means is, if I submitted a request today, the housing provider should respond in a reasonable amount of time, letting me know that they received my request. That doesn't mean they have to provide an answer yes or no within a day or two. There's no hard or fast rules to that. It's everything is reasonable, but we recommend that they at least acknowledge receipt of the request. And then if they need time to assess it, or if they need to request some documentation, they can do that if the disability or the need for the specific accommodation is not obvious. But it's really important that they continue to keep the lines of communication open. We use a term called the interactive process, and that's something that is a two-way kind of good faith back and forth communication between the resident or tenant and the housing provider, um, to engage in, is there something that we can do to assist you? Is there an accommodation or modification that will work? Um, Housing and Urban Development is the federal agency that provides us a lot of guidance, and they are responsible for enforcement of the Fair Housing Act. They advise a little bit about internet documentation because we do see that quite often. And HUD has advised that documentation from the internet is not by itself sufficient to rely on when someone is trying to say that I need an accommodation if if the disability is not obvious or known, and if it's not obvious or known what the need for an assistance animal or something like that or another type of accommodation is needed. So sometimes folks get medical documentation from the internet. There's no hard fast rule that says you cannot have telehealth. There's nothing like that. But if something does come from the internet documentation about your condition or your need for an assistance animal, the housing provider has a right to have reasonably certain information that says that there's a patient doctor relationship and that the doctor knows enough about you and your condition to actually make a diagnosis and recommendation. And HUD tells us that one form of documentation is a note from your healthcare provider, um, confirming your disability or when it's not known or obvious, and with an understanding that they have some kind of patient relationship with you. Next slide, please. Denial of a request. So not every request that is made will be granted. Only reasonable accommodations and modifications are under the law required. So a specific modification or accommodation can be denied for some different reasons, and I'll list them here. When the request is not made by a person with a disability or on behalf of a person with a disability. So you have to have a disability or be making that request on behalf of someone in order to be entitled to an accommodation under disability law. Um, it can be denied if there's no disability related need. If you would like to have your doorway widened or a ramp, but your healthcare provider doesn't substantiate that you meet the definition of a disability, there's no legal obligation for the housing provider to provide an accommodation. Another way, as we just talked about that a little bit earlier, is if what you're requesting would result in an undue financial and administrative burden on the housing provider. If a housing provider uses that as a reason to deny you, they have to be able to substantiate how they determined it was unreasonable financially or administratively. And if they do deny you, they still have to engage in that interactive process to see if there's something else that might meet your needs. And then the final way an accommodation can be denied is if requiring or allowing that accommodation would fundamentally alter the nature of that housing provider's program or services. And an example that I use once in a while is if the tenant said, "Could you please give me a ride to work every day," to their landlord because I can't drive due to my disability status. Well, this is not a service that the housing provider would provide to anyone, staff or tenant, and so it would fundamentally alter the nature of what they're doing. They're offering housing services, not car services, so they wouldn't have to allow that. Again, when a specific request is denied, the housing provider is encouraged to continue that discussion with the requester to see if there's an alternative accommodation that would address their needs. Next slide, please. I did mention assistance animals in that last scenario, but this is a big area that we see. Assistance animals often play a crucial role in assisting people with disabilities. They do a lot of good work. Animals are fantastic. One form of reasonable accommodation may be allowing assistance animal in a rental unit. So that means that housing providers can absolutely have no pet policies, but they have to make exceptions for assistance animals because assistance animals are not the same as pets. An assistance animal is legally defined under the Fair Housing Act as an animal that works, provides assistance, or performs tasks for the benefit of a person with a disability, or an animal that provides emotional support to alleviate one or more identifiable effects of a person with a disability. Again, if there's anything you take away from my presentation is that assistance animals are not pets. They are considered to be medical devices and they're not subject to pet deposits or fees by a housing provider. We do provide a link to the HUD guidance here. It's a really good user-friendly guide, and it's divided up through the lens of a tenant and then through the lens of a landlord or a housing provider, what to do when you're faced with a request for an assistance animal or how to make a request for an accommodation for an assistance animal. Next slide, please. So types of assistance animals, as I mentioned in that last slide, they're legally defined. And the one type is service animals. A service animal is defined as a dog or a miniature horse only. If someone has an actual service animal, it cannot be any other type of animal: cat, hamster, fish, snake, peacock. It has to either be a dog or a miniature horse. Now, that's not to say that assistance animals in housing can't be other types of breeds, but they would not be service animals. It would fall under number 2 category. Service animals or other trained or untrained animals that do work, perform tasks, provide assistance, or provide that therapeutic emotional support for people with disabilities. That number 2 definition includes things like a capuchin monkey that may retrieve items for you. So a capuchin monkey can't be a service animal because the service animal can only be a dog or a miniature horse. But under the Fair Housing Act, people are allowed to have other types of animals in their rental properties that may work or do things for them. And it also includes a big area that we see are emotional support animals. Sometimes people refer to them as ESAs or therapy or comfort animals. They kind of all fall under the same umbrella in that they're not trained to do anything specific to retrieve items or answer the phone, but what they do is provide therapeutic emotional support for a person because of their disability status. So those are the 2 main types of assistance animals that are allowed under the Fair Housing Act. Next slide, please. There are some instances where people, like I said, the capuchin monkey, where they want a unique animal. If the request to have a specific animal involves a unique animal that's not commonly kept in households, and that HUD guidance that I explained earlier, that link, it tells you what common types of animals are: your dogs, your cats, your fishes, your birds, your small rodents. Anything else is considered a unique animal. And if you wanted something like that, if you needed something like that, I should say, for a disability related need, you have the burden of demonstrating that you need that specific unique animal to provide therapeutic support for you because of your disability. Um, there is no requirement that the landlord just allow unique animals. You have to be able to demonstrate that what you're asking for cannot be done by a common household animal. Some examples of the need for a unique animal would be animals that are individually trained to do work that a dog cannot perform. If allergies prevent you from using a dog, you may need a different type of animal. And another way that you could show that you have a unique animal need is that without that animal, the symptoms or effects of your disability will be significantly increased. We've seen goats, we've seen horses, we've seen potbelly pigs, different types of chickens. That doesn't mean that they can be maintained inside the home. It means that there may be a requirement for the landlord to allow them if it's reasonable to do so. So if you have the right kind of property to do that and they're being cared for and there are um, you know, outside uh land or pens to hold these animals. So I just want to mention that. It doesn't mean that you can have every kind of like wildlife living in your home there. Everything is reasonable. What's reasonable? Next slide, please. Accessible parking, I mentioned that earlier. That's kind of another big area we see. Assistance animals and parking are really some of the main areas that we see in fair housing cases. Housing providers, as I said earlier, they're not required to provide tenant parking, but if they do, they have to provide accessible parking as a form of a reasonable accommodation. The requester can ask for a designated accessible parking space, and when we say accessible parking spaces, we're referring to those spaces that are defined under the Americans with Disabilities Act as having the international symbol of accessibility, white and blue sign, the blue or yellow striped access aisles, the proper measurements, things like that, where there's a curb cut. Sometimes people don't need all of the accoutrement that go into an accessible space, but maybe they need a close proximity parking because their mobility is limited, so they can't, they need something closer to the unit. There are different types of requests that can be made. And in these types of cases, the landlord typically pays as the HUD and the Department of Justice have deemed parking to be an accommodation rather than a structural modification. Next slide, please. Oops, I think we might have frozen. Well, this is Tyra speaking. I thought I might escape the technical difficulties, but it got me at the end. I will wait for the slide, but I think I'm near the end of my presentation. So next slide, please. I believe I just have one or two more. Yep, retaliation. So fair housing laws, just like all civil rights laws, prohibit retaliating against a person who exercises their rights under the law, whether it's the Fair Housing Act or our state Persons with Disabilities Civil Rights Act. And there are two ways to exercise your rights. One is by opposition, and that's if you're objecting to any action or practice that is unlawful under the law, or if you're participating in something, if you are filing a complaint yourself, if you are testifying on behalf of yourself or someone else, if you're assisting or participating in any manner of an investigation, a proceeding or hearing under the law itself. Retaliation can include such actions as evicting someone for exercising their rights or harassing them for requesting an accommodation, refusing to rent to somebody after they filed a complaint, or if they've participated in a fair housing investigation. Next slide, please. So folks, if you feel like you've been discriminated against based on what we've talked about today, or any type of unlawful housing discrimination has come your way, please contact our enforcement division. A civil rights claims examiner will listen to your concerns to determine if we have jurisdiction to take a certified complaint, and we can also provide additional resources if we cannot. There are different kind of contact methods here for MDCR. We have our phone number, 313-456-3700, or toll free 800-482-3604. And we also have our email and our online complaint request link here if you would like to click on those, and you can learn more about what we do. Next slide, please. And that brings me to the end of my presentation. Thank you so much for your time tonight. Again, links to our online complaint, our service center, and our toll-free number are here. I will turn it over back to Charles. Thank you. And thank you to the interpreters.
Thank you, Tyra, for sharing a lot of valuable information in so little time. Understanding and honoring accommodation requests can enhance trust between renters and landlords, ultimately contributing to a positive renting experience for all parties involved. Our last speaker will provide an overview of Michigan State Housing Development Authority's, or MSHDA's, Section 8 voucher program, and will share a description of its requirements. It is my pleasure to welcome Marshall Brooks, who's the Director of Rental Assistance and Homeless Solutions at MSHDA, overseeing the administration of the Housing Choice Voucher Program and Emergency Solutions Grant Program. As a statewide PHA, or Public Housing Administrator, MSHDA assists over 28,000 families through its HCV program and provides a waiting list for preference to individuals and families who are certified as homeless through the Continuum of Care Coordinated Entry System. As the direct recipient of HUD ESG funding, MSHDA allocates the funding statewide to ensure all communities can serve individuals and families who are experiencing homelessness or those at risk of homelessness with best practices that lead to housing placement and housing stability. Marshall began his employment with MSHDA in October 2010 and is a graduate of Baker College with a bachelor's degree in business administration. Marshall, thank you for being with us today, and we're excited to hear about MSHDA's Housing Choice Voucher Program and resources. The platform is yours.
All right. Thank you, Charles, and welcome to everybody. Good evening. I'm excited to be here to talk a little bit about a little more about MSHDA's Housing Choice Voucher Program. You've heard in the presentation vouchers being referenced, and we certainly are a big part of that in the state of Michigan. So first, let's define what the Housing Choice Voucher Program is. The Housing Choice Voucher Program is the U.S. Department of Housing and Urban Development's largest rental assistance program. It is administered by public housing authorities, PHAs, across the country. They could be a city, a county, or a state jurisdiction. In Michigan, there are close to 50 public housing authorities, with MSHDA being one of those 50. The voucher program assists very low-income families with rent and utility assistance. One of the core tenets of the Housing Choice Voucher is the word choice, in that it allows families to select a unit they wish to occupy. That unit could be anything from a single-family home, an apartment in an apartment complex, a duplex, or any other housing type. Upon selection of that unit, the PHA does inspect the unit to ensure compliance with program requirements, being a safe and decent housing. And then with the voucher program, families pay at least 30% of their adjusted monthly income towards rent and tenant paid utilities. Typically, it's not more than 40%, with the voucher assistance paying the remainder of the rent directly to the owner or landlord. So MSHDA's Housing Choice Voucher Program is actually the largest statewide voucher program in the country. We assist over 28,000 families across all 83 counties. We do have representation in all 83 counties. With an annual budget of approximately $250 million, MSHDA contracts with private companies and local units of government to help us administer the voucher program. We call these our housing agents. So our housing agents will work directly with applicants and participants of the voucher program to help facilitate and administer the program. As was mentioned in my the introduction, MSHDA does have a homeless preference to the Housing Choice Voucher Program. We have partnered with local continuum of care bodies and housing assessment resource agencies, or HARAs, we call them, offering priority for the next available voucher. Our waiting list can be extensive, with nearly 85,000 families on our waiting list currently. A little bit more data about our voucher program. The average age of our voucher holder is 50 years old. Our average family size is 2.5. Our average income of our voucher holders is around $12,672. 53% of our voucher holders were homeless at admission. 26% are elderly. 47% are persons with disability, and 6% of them veterans. Within the Housing Choice Voucher Program, HUD does allow MSHDA to project-based up to 20% of our budget authority or our vouchers to project-based rental assistance. As was described earlier, the rental assistance is tied to a specific unit within the development. It's not as portable as the Housing Choice Voucher, but it does help us in build capacity and add units to the state, often serving supportive housing populations. In the project-based voucher program, participants are capped at paying 30% of their income, and voucher assistance pays the remainder. One unique thing about the project-based program is that after the initial lease terms, family may request to move to a new unit with a Housing Choice Voucher Program assistance. So moving your project-based voucher to a Housing Choice Voucher. It is possible after 1 year. Within the MSHDA portfolio, we have over 3,000 permanent supportive housing units through project-based developments, and we continue to add more and expand housing opportunities through that program. I'd also like to highlight another program within our voucher program. It is our Key to Own Home Ownership Program. In fact, participants in the voucher program who are renting, we do have the opportunity to those that are mortgage ready to transfer their rental voucher to an ownership an ownership voucher. So participants must be in the voucher program for at least 1 year, must be employed 30 hours per week, earning at least $15,000 per year. There are exceptions for elderly and people with disabilities. So what's unique about the homeownership program, it allows MSHDA to pay part of the mortgage payment while the family remains on the voucher. And it's a really great tool to help build wealth through the building of equity and as well as providing housing stability or stability in housing costs. Once that participant has the mortgage, it's not subject to the same fluctuations as rental costs across the state. And lastly, I want to touch on some of the activities MSHDA is doing to expand housing opportunities to encourage landlord participation in the voucher program. First, we certainly appreciate the new source of income protections provided HC participants. As you heard this evening, it will go a long way to helping to assure that HCV participants can find safe and affordable housing. We're conducting education outreach with landlords, sharing the new source of income protections with our partners, and encouraging landlord participation in our program. To help support landlord participation in the program, MSHDA does offer a landlord damage claim program. So in the unfortunate event where a landlord experiences damage to their unit beyond wear and tear, we do have a fund set aside to help recoup some of those costs for repair of the unit. Landlords can submit a claim and receive up to $3,000 in assistance should they need to. In addition, in Southeast Michigan, MSHDA has implemented what is called small area FMRs, or fair market rents. Typically, the voucher program is limited in the rental subsidy amount based on fair market rents and our established payment standards. Those payment standards are historically have been derived from large, broad area averages of rent. With small area FMRs, we have switched to a zip code based fair market rent, which more closely aligns with the local market. It allows participants maybe to move into areas that were of higher rent, and which was a barrier to finding those units. While also, it's a benefit to landlord. They can collect rents closer to market rent, maybe a bit higher rent than normally could. But really, it's about giving the participant maybe a competitive advantage in the market and to compete for those units that may have otherwise been outside of the affordability calculations that we have. So with that, I want to thank everybody. I want to encourage everyone or anyone interested in MSHDA's programs or anything I've discussed or want more information to go to MSHDA's website. It is michigan.gov/MSHDA. We have lots of information there on the renters tab regarding the project-based vouchers and other subsidies, how to apply to our program, and lots of other materials. So thank you, everybody. I'll turn it back to you, Charles.
Thank you, Marshall, for providing this important information. This program seems highly beneficial, and we encourage attendees to spread the word by sharing the details with their friends and family. And thank you to all of our wonderful presenters for today's session. We will now move to our last area for the day, questions from attendees. For the remaining time, Vicki Levengood, Communications Director for MDCR, will read as many questions as we can get to and direct the question to the appropriate presenter. Vicki, you may now present the first question.
Thank you, Charles. This is Vicki Levengood. We have a terrific crop of questions. We're going to get to as many of those as we can during the time remaining. If we don't get to your question, we will be gathering the responses from our resident experts and sending those responses out to attendees at some point after the session. So we really appreciate your questions. With the first one, what happens if a discrimination complaint contains a conflict of interest for MDCR? I think that would be an appropriate question for Alana.
Hello, everyone. This is Alana speaking again. Vicki, could you repeat the question one more time?
I sure.
Was
Yes.
thing coming back on.
All right. What happens if a discrimination complaint contains a conflict of interest for MDCR?
Right. This is Alana speaking. So I would ask the person who posed that question to expand on it a little bit more. As an attorney, when an individual says conflict of interest, that has a very specific legal meaning in my mind. Specifically that an attorney or maybe an investigator has an interest in one of the parties having an outcome in their favor. So maybe like a family is a party to the complaint, or maybe somebody like owns a rental property, and so then they're the respondent. Right, in those types of situations, generally the department will make sure that no individual with a vested interest in the outcome of a certified complaint is involved with the processing of it, and they'll be firewalled from that. And there's policies and procedures in place on how to report that conflict, and then those steps. But I just want to make sure too that I'm addressing the person's questions with what they're conceptualizing.
Thank you, Alana. If the person who submitted that question wants to send a follow-up, we'll be sure to get an answer to you when we send out the responses to all the questions. The next question, do these laws apply to renters of manufactured homes in manufactured housing parks? Residents own their own homes, but not the land they are on. I think would that maybe be Lucia?
Nikki, can you repeat the last part?
Sure. I'll just repeat the question. Do these
Okay.
laws apply to renters of manufactured homes in manufactured housing parks? Residents own their own homes, but not the land they are on.
Well, in reference to whether the law covers it, that might be legal. However, I can say that we have had cases where there are manufactured homes involved, and it's kind of similar to the homeowners association for condos and things like that. So we do see cases. Again, we handle them all case by case to determine whether or not we have jurisdiction, but we have had cases that involve manufactured homes before.
Thank you, Lucia. Another question, is the landlord responsible for the repair with the house which a tenant lived in a long time, such as garage roof or balcony? I'm not sure who, does anyone have an idea who might be best for that? Possibly Marshall?
Sure, I can speak to the voucher program. So the landlord is responsible to maintain the unit in a safe and decent fashion. We do conduct biannual inspections under the HUD's NSPIRE inspection standard. So for the voucher program, absolutely yes. The landlord is responsible to maintain that unit is safe, in compliance with those standards. And then if a participant to the voucher program had concerns about that, they can certainly reach out to their housing agent and request a special inspection at any time.
Thank you, Marshall.
Mhm.
The next question, can a landlord require a tenant to have renter insurance? Catherine, would you know that answer?
This is Catherine speaking. Yes, it will be my general answer. As long as the landlord is requiring all tenants to have renters insurance, there isn't it won't be a violation under the ELCRA or the Person with Disabilities Civil Rights Act to require a tenant to have renters insurance.
Thank you so much. The next question. I'm confused about the new income laws. If my income requirement is 3 times the rent amount, when rent is, for example, $800 a month, is it illegal to reject an SSI applicant who makes $2,000 a month?
This is Catherine speaking. Just to be clear, I just want to say that MDCR can't actually respond to specific instances that are occurring, anything that might become an actual complaint in the future. So I'm not sure if this is a general question. Just trying to understand the source of income amendments to the ELCRA. The source of income amendments to the ELCRA allow for housing providers or landlords to have whatever their requirements are for renting a property. So if a housing provider has income requirements before someone can rent their property, that won't be a violation of the source of income amendments under the ELCRA.
Thank you very much. The next question. Does the reasonable accommodation for unique animals, in parentheses, they have farm type animals, under FHA HUD override zoning ordinances? For example, no chickens are allowed in city limits, but under FHA, I can still have them.
This is Catherine speaking. I think this is once again going to be one of those specific examples. I see Alana's already on with it, so I'm going to go ahead and mute.
This is Alana speaking. I actually think, given that Tyra was the expert on it during our presentation today, Tyra, you take point, and if I have any extra comments, I'll tag on at the end.
Sure. So federal courts have held that this is this exact issue, right? So waiving the zoning ordinance to permit a unique animal may be a reasonable accommodation under the Fair Housing Act or under the state law. One thing you should know about fair housing law and all law, there's no yes or no bright line sometimes, right? And especially when we're talking about disability and accommodations, everything is what's reasonable. So it may not override, but there may be situations or conditions where it is reasonable to provide a exception to that law. And we've seen these types of cases. We've seen many of them. So it's possible. And I'll let Alana, if she has anything else to add to that.
This is Alana speaking. No, nothing else to add. Mic drop for Tyra.
Thank you both. The next question. I have a landlord that doesn't want to rent to a group of college students. Is this considered discrimination? I think, Alana, this one would fall in your area.
Hi, this is Alana speaking. So gonna reiterate, I know what Catherine already said, right? We can't necessarily give any specific comments about any one case. So of course, please feel welcome to bring the specific allegations to MDCR for the intake unit to assess and process if there is in fact jurisdiction over those allegations.
Thank you, Lana. The next question will go to Tyra. When a tenant says that he has an emotional support animal, what documents can I ask for to verify, or do I just take his word?
Okay, so if you remember back what I said in the presentation, landlords are, and housing providers are entitled under state and federal law to reasonable assurances. And that doesn't give us a checklist of documents, right? Reasonable assurances that the person meets the definition of a person with a disability and has a disability related need for that particular accommodation. And what you're speaking of is an emotional support animal. What is a reasonable assurance? If it's disability related, HUD tells us it's generally a note from the doctor, right? And this is when we're talking about disabilities that are not obvious or already known. So here, emotional support animal is generally needed for psychiatric or emotional type disabilities. So those are not always obvious or apparent. So you have the right to request something from a healthcare provider that would substantiate that they're a person with a disability and that they have the need for the animal.
Thank you, Tyra. The next question. I've read that Michigan passed a law that no longer allows insurance companies to discriminate against specific breeds of dogs when it comes to rentals, particularly when it comes to ESAs and service dogs. The individual asked the question also said they'd like to read such laws, and we can send the group links to these laws afterward. But I thought, Tyra, you might want to just take a minute and respond if you have the answer to that.
Sure. I think you might be referring to some diffs bulletins that were issued, but the law has always been the law that says, if you recall, I said housing, it applies to not only the housing provider, but the insurance company, financial institutions, all of that. So when we're talking about insurance, it says HUD guidance is really clear. It says that you can, like I said, a housing provider can say, you can't have animals here, but they have to make exceptions for service or assistance animals. They can also say no dangerous breeds, right? They can say no pit bulls or whatever you consider a dangerous breed. No Rottweilers, no Chihuahuas, because, you know, they can do some damage too. But again, they have to make exceptions when it comes to animals that are a medical device, because that's what these animals are. So the Fair Housing Act already tells us that. And even though our state law doesn't explicitly mention assistance animals, it says it talks about accommodations. And we know from case law and guidance that accommodations can include animals.
Thank you, Tyra. This question addresses something we've already discussed, but I think it might be good to reiterate what we can in response. What is the maximum amount of funds income required for a rental deposit? For example, 3 times the amount of rent. I think maybe I'll toss that one to Marshall, even though it may not be something that either of our agencies can answer.
Can you restate the question, please? The
Sure.
maximum amount of
Yes.
security deposit or rent?
What is the maximum amount of funds or income required for a rental deposit? For example, 3 times the amount of rent.
I am not the authority on that. I would leave it to the lawyers to help us respond to that.
Alana and or Catherine, I know Catherine, you have responded about difficult to get into very narrow specifics, but if there's anything either of you could add, that would be helpful.
This is Catherine speaking. At this time, there isn't any codified law that specifically states that a landlord can't require income limits. And so I know in recent years, those income limits have increased sometimes to 3 times the rental amount. And so I know that there was an expectation that the source of income amendments to the ELCRA would cover this, but like I stated earlier, it is not, a landlord is not in violation of the source of income amendments of the ELCRA if they impose income requirements on their rental units. It's not a part of protected income.
Thank you for clarifying that, Catherine. Here's a question for Marshall. Why does MSHDA tell stakeholders to not accept self-certification for the housing letter to access HMIS for vouchers?
Yeah, thank you for that question. I'm not quite following what the participant is asking regarding self-certification for housing letters. So if the person who asked that question wants to maybe provide some more clarification, we can certainly come back to it and maybe I can address it more completely.
Thank you, Marshall. I'm just scrolling through to see what we have missed. I think we had this question in another forum. I'll ask it again. Can landlords require a tenant to have renter insurance, a single house tenant by the owner?
Hi, Vicky. This is Alana. I want to jump in because I do want to follow up on the question posed a little earlier about expectations for renters, source of income, minimum or maximum amount of funds or income required. And I just wanted to highlight or touch for the group, right? MDCR's jurisdiction is limited in scope of enforcing the ELCRA, as well as the Persons with Disabilities Civil Rights Act, and the federal counterpart laws that were authorized to enforce. And for purposes of housing, that's the Fair Housing Act, right? FHA. So things, if there are other laws that do govern those requirements, right, that's not within our jurisdiction. And so, so long as a respondent, landlord, or landowner is applying a term or condition to rent a dwelling consistently, regardless of a person's source of income or any of the other protected bases, those generally on their face don't violate the laws MDCR enforces. Now, there may be other laws violated, and if so, there would be respective agencies to address those that are not MDCR specific. And so I just want to make sure we put that out there and understand what's MDCR's scope of jurisdiction, what's within our expertise, just to help provide a little bit more clarification. So I apologize for interrupting your flow there, Vicki.
Oh, no, you didn't at all. No, that was fine. We have another question that is very specific, but I want to toss it to Tyra so you can maybe address some of this in a more global way. The question is there a good resource that MDCR has or can share regarding rental apartment reasonable accommodations? And then they give some examples. One, taller and larger size toilet that isn't so low to the floor. Two, more lighting over a front door and with a window in an apartment with one window at the front of the unit. Steps off of a deck that doesn't have a handrail at all. Those kinds of questions. Tyra?
This is Tyra speaking. I think when we provide the PowerPoints, we can also provide, but I can tell you here too. So it really does depend on whether this is a whole other presentation, but whether the unit is considered a multifamily dwelling under the Fair Housing Act, and it has really specific requirements for when it was built, and so how it has to be built. And you can look to the Fair Housing Act and like the uniform standards for design and construction standards will tell you like how it has to be built. But when it comes to other things like that, you can look to the Americans with Disabilities Act guidance, because it will have measurements for accessible toilets, reach space for counters. If someone is utilizing like a mobility device, what is the knee and toe space? So lots of guidance on the Department of Justice website for specific requirements of how things need to be built, as well as the U.S. Access Board website that will help you as well to look at some of those measurements and guidance.
Thank you, Tyra. This question I'm going to pose to the legal team or Lucia. It's again about manufactured home communities. Do all these discrimination clauses apply to renters in manufactured home communities, or does the park lease take precedence because it's like, quote, private community and they can require whatever they want?
This is Alana speaking. That's really going to depend on the case, right? So depending on what's alleged as the harm for that case, alleged to, what are the terms and conditions within a contract between the parties, that could have some influence or relevance to the outcome of a case. So I can't give a blanket answer to that effect. So I wish I could. It's hard to get an attorney to get a bright line rule, but that's why they pay us the money to do this job, is to work through those ambiguities and make those fact-specific determinations on a case-by-case basis.
Thank you, Alana. The next question. As a renter, I work remote from home and I choose telehealth for as many possible medical or mental health appointments. What is a good phrase to state to the landlord or property management company about why maintenance access is not available during my telehealth appointments. I'm not sure who to direct that to. So we'll leave it up to anyone who thinks they may have something relevant to say with that.
This is Charles speaking, and this will be our final question.
This,
This is
Oh.
Tyra. I guess well, and we can tag team. I think if it's a part of an accommodation request, because we can't provide legal advice, obviously, or tell you exactly what to do or say. But if you're doing anything as part of a request for an accommodation, as we say, it's best to put things in writing to the landlord. So you keep that paper trail and then you can follow up with that. So any requests that are disability related, I would submit those in writing.
Thank you, Tyra. I think I'm going to toss it back to Charles now. Thank you for the terrific questions.
This is Charles speaking. Thank you, Vicki. As we close, I want to thank all of our panelists for sharing their time, expertise, and talent with us today. Your information and insights have been invaluable. Thank you to all of the MDCR staff working behind the scenes, as well as our accommodation providers for making this a successful event. Finally, we thank all of our registered participants and those who have viewed via live stream for joining us today to learn more about this important topic. As we mentioned earlier, this session was recorded and you can find it on our YouTube channel at MI Civil Rights. We will also provide copies of all materials used today after the session. Thank you again for joining us and take good care.